The High Court judgment by Justice James Omotosho has left tongues wagging. According to some, the judgment is not only in bad taste, but will negatively affect the fragile peace and security in the state since the political crisis between immediate past Governor Nyesom Wike and the incumbent Siminalayi Fubara began.
I feel that judgment is belated. It's belated in the sense that the issue on the front burner is now the legality of those 27 lawmakers that decamped from the PDP to the APC. Now, this is not even subject for debate. The Constitution is very clear. You decamp, you lose your seat. So when we're talking about such a sensitive matter that is trying to cross a red line, which has to do with our Constitution, the judiciary is not supposed to play within that gallery anymore. The judiciary is supposed to be firm.
The law should be one and should be interpreted as one. If you spell it out or interpret it in different way, the Constitution also have to be used. Or does it mean that the orders that was given or dished out did not follow constitutional guidelines? Because if there was a constitutional guidelines and the interpretation was based on the constitutional guideline, then there should be a particular system that the judgment should follow.
I will quickly say that this judgment has ruptured the already fragile peace we have and we are enjoying in the state. In the sense that, all this while because of the yet to come Supreme Court decision, there has been this palpable calm, this uneasy calm in the state that people are, what will happen? Are there moves to unseat the incumbent governor of the state? Now, what does it mean to me? I am not a lawyer, but from the social analytical point of view, it is clear that telling a governor to go and start a process already concluded is like making him to be helpless.
But these legal practitioners have different perspectives.
I think the court clearly stated that, look, you cannot go and give or deliver a budgetary speech or give your budgetary analysis before any member of the House of Assembly, because that order covers it. The court frowned against it. I think that's the whole essence of that judgment. The later reports I was getting from the media that the judgment had given an approval to the other member. No, I don't think that was what the court did. Though I had not read the judgment in its entirety, but I think the judgment restricted itself. The court restricted itself to the order it made and the essence of the flouting of that order by the governor and its implications. The implication is that the budget he presented to the four members of the House of Assembly is a nullity, which is very correct in the circumstances, because there's an order restraining him from doing anything. In other words, he cannot give, it does not lie his position to give recognition to one House of Assembly outside the other.
It's really worrisome. It's one thing that one will continue to interrogate in the coming days, the propriety or otherwise of that kind of compelling order, really. But I acknowledge that a valid law can only cease to be so on two grounds. One is where the legislative house that enacted that law repeals that law, then it ceases to be enforced. And I don't think that that is the situation here, because the Rivers State House of Assembly has not considered a repeal of the appropriation law, if you like, the 2024 financial year appropriation law for Rivers State. The other ground will be where a court of law, a competent court, upon a suit for that purpose, challenging the validity of that law, then the court decides that that law is either inconsistent with the provisions of the Constitution or did not follow the procedure of enactment of a law in that legislative house, then it could be set aside.
These respondents have some advice to all those involved in the Rivers political crisis.
The Rivers State here is quite a volatile area. And so decisions on these issues, they have to be very, very circumspect and very careful on what turns out, because one little thing could ignite a whole wave of controversy and crisis and and the peace and security that you are looking for will tend to become very much more elusive than we ever envisaged.
We have to maintain the sanity and independence of our state, put our people first, put our development first, and not to sell ourselves out for that porridge that will eventually purge us. Because selling out the state in order to take hold of power will eventually have a backlash.
Recall a federal high court in Abuja had ruled that the presentation and passage of the Rivers State 2024 budget by the four-member Ehe Edison-led House of Assembly was an aberration, going ahead to void and set aside the budget on grounds of illegality and unconstitutionality. The Justice Omotosho Court also restored the leadership of the Martin Ameule, leader of the 25 legislators loyal to former Governor Nyesom Wike, as a lawful and authentic Speaker of the State House of Assembly. But in another breath, another federal high court sitting in Abuja ordered all the parties to maintain the status quo. From Port Harcourt, the Rivers State capital, Andy Omano, Arise News.